SJC-11954, Jeffrey M. Lascher v. Tricia Leslie-Lascher.
Good afternoon, Your Honors.
Mr. Lascher, you've got your 10 minutes, and that'll start once Mr. Keneally has finished his distribution. And you may proceed, sir.
Good afternoon, Your Honors. My name is Jeffrey Lascher. I'm representing myself. My appeal has two basic issues that I'm trying to deal with. The first and most important is obviously the recusal issue. Judge Riley of the Barnstable Probate and Family Court on March 25th of 2015, during a hearing, had told myself and my probate attorney at the time that he had received a gift from the defendant, Miss Leslie, of a Bible, had turned it over to the CPAC of the state police, and that he received that on December 4th, which was several hearings after we had already had several hearings since the December 4th date. Miss Leslie, who was present in court, admitted to mailing the gift. Judge Riley went on, as I provided the transcripts to the hearing, he went on to actually recommend that he had done an internal and external evaluation of recusal, and that while in his heart the internal would still be okay with him, but the external he would, if we filed a motion, allow the motion to recuse. He gave myself and my attorney time to go out in the hallway and discuss it and to come back in. We came back, we went out, we discussed it, we came back in, we did file the motion to recuse. On the table at the time, obviously it's a very extenuating case, it's gone on for years. I'm sure you've all read the briefs. I had a motion for relief under Rule 60 for fraud during negotiations of the original divorce. I had a motion to reconsider, being that I have custody of the children and I'm currently on disability, that I could not pay a balance that was owed to Miss Leslie from the original divorce. That was a motion to reconsider on that too. And then obviously we asked him to recuse himself. He did recuse himself and said that we would get a later date for any future hearings with the other judge.
If I could ask you, I mean, generally, when one appeals to a single justice of this court, it is only for extraordinary relief that cannot be obtained through the usual appellate process. Why would you not simply seek to file a late notice of appeal in the Probate and Family Court and seek to bring that as part of your claim with regard to the judgment before the appeals court in the ordinary course of an appeal?
I did file a motion to reconsider. I did file the motion for relief. Both of them were under Judge Riley at the time. The recusal kind of hit it right in the middle of it. I did file, I was under the assumption that the motion for reconsideration was a form of appeal.
Appeal to him, not necessarily an appeal to the appeals court.
I understand. I did pay the money that was ordered from Judge Riley, just to make that go away. Obviously, I'm on disability. I'm raising two small children. The other person involved is awaiting trial in Superior Court for some pretty serious charges. I'm on disability. I'm of little means. When we signed the divorce, I did agree for a one-time payment of an alimony, which was due. I can't pay it. Judge Riley in the past had ruled me to pay it even though I couldn't pay it, and found me in contempt. For being a fear with my children and everything that's going on, I asked for relief. And I was denied. I've been denied all the way through. I did file under 231, Section 118 with the appellate court to the single justice practice, which was denied. And then I did appeal to the single justice here, and then brought it to this court. I mean, the recusal issue I understand, but under 211 Subject 3, I mean, I have a right to be judged impartially. I mean, it's written as you come in this honorable court. So I'm just trying to, I have a right to raise my kids and
So you're saying he should never have ruled on this at all?
well, I'm saying Yes, on March, he ruled on my motion for reconsideration and my motion for relief.
After he had said he
40
was gonna
days after he recused himself.
But he said but I thought when he recused himself, he said he was going to rule on those matters and that there was no objection to him doing so.
He did say he was going to rule on them.
Was there any objection to him doing that?
I did not object. He did not mention, would you like to object or anything like that. You have to understand that there's nothing in my case that could happen where you could actually say, well, I could see that happening. I mean, it's just bombardment after bombardment on me and everybody in my life. And here all of a sudden, I'm here for something else, and all of a sudden I hear about a recusal from a judge who I have a lot of respect for, who was our judge for over 2 years. And next thing I know, I'm starting all over again, and it's just a difficult situation. So maybe did I err in not saying I object? I had to assume that Judge Riley at the time, knowing that he was recusing himself, waiting for us to come in that day to tell us that he was going to allow it up front. In my mind, from the moment he asked us to go, that he would allow it, he says, that he would allow it, that if I went out there, I would allow it. So from that point on, he already has a bias. I mean, he's admitted to some kind of bias. And for him, with the ups and downs of this case and everything that's gone on, and the restraining orders and things of that nature, the room was spinning for me. I mean, here I just lost the judge. Not that he had not ruled against me in the past. He had. He's ruled for me. He's ruled against me. Obviously, the things that were important were obviously my life being threatened and what I had to go through. But I kind of figured that if he recused himself, obviously there's only one other judge in Barnstable, that he would communicate with Judge Scandora and something would be done. That's my problem, is that I think he erred in his way. His very denial of the two motions proves the recusal issue. I mean, obviously I'm not an attorney, so I did the best I could. But in Parental versus Jacobson, in the Massachusetts Appellate Court, a judge partially recused himself from a case. He said that he could not hold a non-jury trial, but he would hold a jury trial. And they found that that once a judge recuses himself as a judge, under his canons, under Section 309, he knows he needs to be out. He can't rule. I know, for example, that Justice Botsford ruled on my single justice petition. I understand that. Justice Botsford understands that. Judge Riley should have understood, hey, I'm recusing myself. I'm going out of my way to tell you guys to file a motion to get me off this case because of what's happened. And then 2 months later, he rules. Really, he should have given it to the other judge. Or with the immense evidence that I have that she did commit fraud, including the U.S. Justice Department finding over $500,000 worth of assets during a bankruptcy that she filed, he should have at least called for a hearing and let me present my case. I mean, I have 2 small girls. I'm on disability. My life has changed forever. All I'm asking is to not be bound by, I've sat and I've watched a lot of cases before this honorable court. Some very complicated law. This is more common sense. I mean, this is very common sense. I have 2 small children I need to raise. She lied during the negotiations in good faith for the divorce agreement. That's it. I mean, she shouldn't, I can't pay somebody who is indicted for trying to have me killed. It doesn't make any sense. Eventually the law does, it just comes down to common sense.
All right. Well, so, sir, thank you. 2 things. One, we will take the matter under advisement, meaning we will consider it and render a decision. The other thing is, I'm not sure if you are aware of it, but we do now have an appellate pro bono clinic for those who appear without counsel, which would provide you with the opportunity perhaps to confer with an attorney with regard to what you describe as that I understand to be a very complicated matter. And Clerk Keneally, I think, can help you, inform you as to the hours of that clinic. So you may want to confer with him as to whether you may make use of that particular clinic, because you are representing yourself in a rather complicated matter. Okay?
Thank you, Your Honor.
Thank you.
Thank you, Your Honors.